Hey everyone, my name is Paul Vacheski and welcome to the Real Estate Classroom YouTube channel. My mission is simple: to help you pass your exam the first time. And to do that, you need to know important key real estate vocabulary terms for your real estate exam. And we're going to finish up all 300 in this video. So 292, what is a dual contract? A dual contract is a process where two different contracts are drawn up by the same parties in a single real estate transaction. And the reason that they do it is one of the contracts for a higher amount will be given to the lender so the borrower can get more money. The second contract is between the buyer and the seller, but that's given to the seller. So let me give you an example. Buyer and seller agree to purchase the property for $100,000. They draw up a contract that is for the price of the home. However, the buyer and seller draw up a second contract for $150,000, and that contract is given to the lender. So the lender processes the $150,000 transaction. It goes to closing, and the seller gets $150,000, and then the seller kicks back $50,000 to the buyer. Usually there's some kind of quid pro quo that's in there, like the seller's going to get a certain percentage of that $50,000 for participating. It was actually very common prior to the mortgage meltdown in 2009 and 10, but it is illegal to do, and the federal government does actively pursue claims of that. So we don't see them a whole lot anymore. Dual contracts are illegal, and you have to know what they are for your exam. 293, what is the Statute of Frauds? Well, first of all, you have to know that this is a very important key real estate term that you need to know for your real estate exam. Secondly is, these are state laws. So all 50 states have their own version of the Statute of Frauds. But the things that we need to know for the exam are, not all the states have the same set. It's not consistent from state to state on what the Statute of Fraud says. But one of the things that's really consistent, and it typically defines, is what types of contracts relating to real estate have to be in writing for them to be valid and enforceable. So for example, most states have that if you're going to enter into a purchase agreement, a listing agreement, some type of contract that conveys title, then for that contract to be valid, it has to be in writing for it to be valid and enforceable. However, many states have an exemption in there for leasing. So for example, a common one that's out there is a residential lease, for example, an apartment lease of 1 year or less, can be verbal and still be valid and enforceable. Anything over a year, it must be in writing. That is a common one. Other states, it'll have where leasing is completely exempted. So it's real important that you guys know for your state side of your exam what your state Statute of Frauds requires and exempts. But what you're going to see on the national exam for the most part is the Statute of Frauds requires all real estate contracts to be in writing, with the exception of a residential lease of 1 year or less. 294 is called the Parole Evidence Rule. This comes up when there is a contract dispute. We never see this really in real estate itself. This is usually the second phase when attorneys are involved and there's some kind of legal dispute that's going on. The Parole Evidence Rule says any agreement that is not contained within that written contract can't be introduced as evidence. So let's say the buyer seller into a purchase agreement, and let's say the purchase price is $100,000. But after the period, after the time that the buyer and seller execute the contract, but it hasn't closed yet, that period between contract to close, the buyer seller verbally agree to up the price $20,000, but they don't put it in writing as an addendum or an amendment to the contract. After closing, the seller goes, "Where's my $20,000?" So the seller files a lawsuit against the buyer. The buyer's going to claim parole evidence rule. Yeah, we might have agreed to this. However, this was something that wasn't put in writing, and so therefore it has no valid bearing in the outcome. That's the parole evidence rule. Assignment of contract. So an assignment is a contract of and in itself. It is a legal instrument. It's a sole standing contract, and it's used to transfer or assign a person's legal interest in a contract to a third party. We've talked about this before in other videos, but let me give you a quick example. Buyer-seller enter into a purchase agreement. Purchaser decides they don't want to sell it, but let's say that their neighbor wants to buy the house. And so the neighbor is called the assignee. The buyer is called the assignor. So the assignor, which is the buyer, they just sign an assignment contract, transferring their interest in that purchase contract to their neighbor. Now, you can't renegotiate any terms. The assignee, which is the neighbor, they have every obligation to fulfill and complete all the terms of that original contract. But there is a second document called an assignment of contract that actually transfers the legal interest from the buyer, in this case, to the buyer's neighbor, from the assignor to the assignee. That's an assignment of contract. 296 is the statute of limitations. Now, the next couple of vocabulary words all evolve around what we call affirmative defenses. So if a party in a real estate contract gets sued, there may be some legal defenses that defendant can raise in court to protect their interest. One of them is the statute of limitations. It's a legal defense, and it's usually a time period that's within the statute that's been established that prohibits a party from bringing any kind of legal action. Now, let me give you a couple of examples. We really see this a lot in criminal law. So let's say, for example, manslaughter. Let's say that someone committed manslaughter, but in that state that they reside in, manslaughter has a 7-year statute of limitations. That means that if the state doesn't bring criminal charges against that person within that 7 years, if it goes into the 8th year, then they even though they can never bring charges against them. And even if the person that committed manslaughter said, yeah, I did it, they admit to it, they still, the state could not bring charges because they waited too long and it surpassed the statute of limitations. We see this in contract law as well. So for example, where I'm at in Nebraska, most contracts have a 4-year statute of limitations. So if a buyer wants to sue a seller, then they have to do it within the first 4 years after closing. If they wait to the 5th year, then the statute of limitations is going to be a legal defense for that seller. Laches. This is an old English common law legal defense, and it simply says this. Okay, even if it's true, so someone sues me, I can say, okay, even if it was true from 30 years ago, even if it was, the plaintiff who's suing me, they simply waited too long to bring suit against me. I will tell you, and I almost don't want to bring this up, but it illustrates perfectly what I'm talking about. You know, when the Catholic Church was being sued for some of the inappropriate activities by priests that happened many, many years ago, 30, 40, 50 years ago, one of the defenses that they would raise when they were being sued is, hey, even if it did happen, this was 50 years ago or 60 years ago. They waited too long to bring suit. So it's not an admission of guilt. It's just simply saying you waited too long. And it's still a legal defense that is employed from time to time in today's legal system. 298, specific performance. Again, this is a legal remedy that allows a harmed party to a contract to ask a court to require the breaching party to specifically perform as required by the terms of the contract. Let me give you two of the most common examples in real estate. Real estate is not substitutable. There are no two identical pieces of property. So therefore, there is this specific performance issue that comes up in real estate. Buyer-seller enter into a purchase contract. The seller simply decides that they don't want to sell. They just say, you know what, I'm breaching the contract, I'm not going to sell. The buyer could file suit in court for specific performance that requires the seller to specifically perform as required by the terms of the contract, which was to go to closing and transfer title to the buyer, and vice versa. A seller could sue a buyer for the same. Specific performance is really a good tool in real estate where the product that's being sold is not easily substituted. 299, what is a patent defect? A patent defect is a material defect in the material condition of the property that's in plain view. The way that I remembered this when I was a student is patent defect, plain view, P&P. Patent defect is simply something you can see in plain view, like a hole in the wall, termite damage that is readily visible, etc. And last but not least, number 300, latent defect. A latent defect is a defect in the material condition of a piece of property that is hidden from view. So let's say that there was termite damage, but the drywall is covering up the joists that have the termite damage. You can't readily or plain view see the damage. That's considered what's called a latent defect. If you're going to continue studying for your real estate exam, it might be a good idea to check out this video. See everyone in my next video.